Exactly.
Here's Ron.
Hey, you gentlemen, you provoked me to wear my bolo tie. I bet you don't have a diamond bolo tie.
Maybe the governor does. I don't.
No, I'm traditional.
Commissioner Villanueva just blew everyone out of the water.
All right, Chair, we're all here. You're muted.
Call the meeting to order. Good morning. First of all, I want to welcome our newest member, the Honorable Celia Foy Castillo. Good morning, Celia, and welcome.
Good morning. Thank you. It's like I told the other members, it's a pleasure and an honor to be here. I look forward to working with all the commissioners and the staff. What the Ethics Commission has done over the past 2 years is amazing, and I'm really happy to be a part of it.
We are equally delighted to have you here, and it's nice to see you after so many years of not seeing you. Okay, the meeting having been called to order, let me call the roll. Commissioner Baker.
Present.
Commissioner Bluestone.
Here.
Commissioner Carruthers.
Here.
Commissioner Castillo.
Here.
Commissioner Solomon.
Present.
And Commissioner Villanueva.
Here.
All right, we have a full complement. Turning next to item number 2, which is approval of the agenda. You all have it. Is there a motion and a second?
So moved.
Second.
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. Approval of the agenda is approved. And then turning to the minutes of the June 4th, 2021 meeting. Is there a motion and a second to approve?
Move to approve the minutes.
Approval of the June 4th minutes.
Move to approve the minutes.
Yes.
Second.
Thank you. All right, then Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. So my part is done. Thanks. See you guys later. Item number 1 under meeting items, advisory opinion number 2021-10. Jeremy.
Okay, thank you, Chair. First, before I introduce this advisory opinion, let me just say to members of the public that are here, perhaps to follow one of the commission's administrative cases, that the commission has a number of items to take care of this morning before it goes into closed session to discuss administrative cases. And after it comes out of closed session, it'll take actions on administrative cases. So it could be a couple of hours before the commission gets there. And I just want to give that heads up to members of the public that might be here following various of the administrative cases. So with that being said, I'd like to present to the commission advisory opinion 2021-10. This is an interesting and important advisory opinion, I believe. It poses the question under Section 3C of the Financial Disclosure Act, who is included within the classification of a state agency head and therefore must file an annual financial disclosure statement. The Financial Disclosure Act is relatively clear in most of its classifications with respect to who must file financial disclosures. It's clear that members of the legislature must file, candidates for those offices must file, statewide elected officials and candidates to those offices must file, members of boards and commissions that are confirmed by the Senate must file. But the Financial Disclosure Act also says that state agency heads must file, and that is a little less clear. with respect to who is included and who is excluded in that statutory term. And so the commission received a request for advisory opinion about that question, specifically that question. And the advisory opinion proposes the following answer, that a state agency head is the person or persons who are ultimately responsible for exercising the powers of a state agency's official acts or expending the agency's appropriated funds. And the way that the advisory opinion drives to that conclusion is that it kind of considers the purpose of the Financial Disclosure Act, reflecting on the Financial Disclosure Act's adoption in 1993, enactment in 1993, along several of the others of New Mexico's important ethics laws, the Governmental Conduct Act being primary. And so the financial disclosure requirements in the Financial Disclosure Act really have a twofold purpose. The first is to enable officials in the state to formally disclose real or potential conflicts of interest, which they have a duty to do under the Governmental Conduct Act. And the Financial Disclosure Act also allows members of the public to check that a legislator or public officer is in fact using the powers and resources of their office for the benefit of the public interest and not to obtain any personal or private benefit. And so thinking about, which is also a requirement of the Governmental Conduct Act in Section 3A of the Governmental Conduct Act. So thinking about those very central ethical principles and laws in the Governmental Conduct Act, and thinking about the purpose of the Financial Disclosure Act to help to promote them, that kind of helps with an interpretation of a state agency being a state entity that has powers, that's not just purely advisory, but has powers to alter the rights, powers, liabilities, duties of others, and also to expend appropriated state funds. And so with that kind of understanding of what a state agency is among all the various state entities, the heads of those state agencies are the persons who are required to file financial disclosures. That's the reasoning of this advisory opinion. And then the advisory opinion kind of draws a kind of durable heuristic that I think will be helpful for the State Ethics Commission and the Secretary of State to enforce the Financial Disclosure Act with respect to state agency heads in the years to come. And the heuristic is this: if a state agency receives an annual appropriation, either in Section 4 of the General Appropriations Act or in the feed bill, HB 1, then that entity is a state agency. It yearly receives appropriated funds, which it expends, which the head of that agency is ultimately responsible for expending those funds. And those are the state agency heads that I think the Secretary of State and the Commission under Section 3C of the Financial Disclosure Act are most concerned with receiving and ensuring that there are timely and accurate financial disclosures. And so, Mr. Chair, I'm happy to answer any questions related to this draft opinion.
We'll start with the obvious. Jeff?
Just one comment, actually two comments. First, I thought the advisory opinion was very well written and reasoned. What I would like going forward is if staff can put together a list of all the agencies, the name perhaps of the current agency head, so that there's no misunderstanding or disagreement as to who is or is not included, who needs to file an annual financial disclosure statement. And that'll give agency heads an opportunity to say, wait, stop. I don't think that applies to me. I don't think that applies to my agency. And so we can have that conversation. But I think whether it's an addendum or a separate piece of paper, I think that would be helpful if you can put that together in the next few months.
Well, Mr. Chair and Commissioner Baker, we're working on a large spreadsheet that lists every state agency that under this advisory opinion, the head of which would have to file. That's about 123 agencies. The boards and commissioners that are subject to Senate confirmation is kind of another tab in that large spreadsheet that we're figuring out. We have to confirm, under the law that who the head is, whether it's a director or a cabinet secretary, et cetera. But this is a project that we are working on. We have been working on it with the Secretary of State's office for several months. And I think that this agency and the Secretary of State's office, after this advisory opinion is issued, we will have a kind of definitive list before the 2022 cycle of financial disclosures. We'll kind of have a playbook. And that's that larger project, the vindication and enforcement of the Financial Disclosure Act. This advisory opinion is very much part and parcel of that larger project.
Thank you.
Thank you. Commissioner Bluestone?
Thank you, Chair. And I also want to commend you on the advisory opinion draft. I think it's very, very well done. One question that occurs to me as I was just looking through it again here this morning and your explanation is, do you believe that the requirements, the two elements you talked about, the receipt of appropriated funds and the ability to alter rights and responsibilities, both need to be satisfied, or does only one of those two criteria need to be satisfied?
Mr. Chair and Commissioner Bluestone, that's a nice question. I think it's a disjunctive that either would make the Financial Disclosure Act applicable given its purposes. But ultimately, I think where the Commission's efforts with respect to compliance and enforcement should lie is kind of in that same heuristic, that if you're an agency that receives a Section 4 appropriation or an appropriation in the feed bill, it's those heads of those agencies that the Commission ought to first be interested in compliance. Now, if there are some strange cases. For example, in the 2021 General Appropriations Act, there was an advisory committee that received a very small appropriation in Section 4, like a $7,000 appropriation to a kind of advisory committee. That's an outlier for a Section 4 appropriation. And if we dug into it and received a request for an informal opinion or a letter opinion about whether or not the members or heads of that agency should have to file, I think that'd be the instance where we could really explore, whether or not the two elements are conjunctive or disjunctive for the purposes of requiring a filing. There will be years in which certain very small agencies might receive Section 4 appropriations where they haven't before, and the appropriation somehow ended up in Section 4 as opposed to the latter sections of the General Appropriations Act. This is a long-winded way of saying that I think that kind of legally, properly, it's an or. If you're a head of an agency that exercises state power such that you're altering the rights and duties of other people in the state of New Mexico or elsewhere, you're a state agency and a state agency head. Similarly, if you receive an appropriation, you're expending state funds, the same purposes behind the Financial Disclosure Act would apply. But again, there will be cases where there are very small entities where, as a matter of course, the Commission might not press for those financial disclosures. And I could go back and find whichever small advisory committee received that kind of $7,000 other funds appropriation. But yeah, there will, the advisory opinion is is kind of in the end advisory and doesn't necessarily pretend to answer all the open questions. There are still open questions about the applicability of Section 3A. And indeed, the opinion notes that were those persons that think that there's an open question with respect to whether or not they should file, the advisory opinion asked them to submit a request for an informal letter opinion to the commission so that we can close those openings as they pop up.
Thank you. I think that's helpful. I think the opinion is written in terms of the conjunctive, that it has to be both 1 and 2. And I just wonder if you want to look at that further to make it in the disjunctive as 1 or 2. And as a practical matter, I'm not sure that this issue would ever arise with any agency other than one that gets appropriated funds. I mean, that's what makes it a public agency, it seems to me. But I don't have strong feelings about it. I think we want to err on the side of disclosure as much as possible. And that's why the disjunctive might work a little better.
Mr. Chair and Commissioner Bluestone, that word "or" is in the first sentence of the answer. You might be right that somewhere in the later in the opinion it's more equivocal, but at least in the first sentence of the answer, third line, the disjunctive's there.
Okay, gotcha. Yeah, I think it's later in the opinion where the and applies, but thank you. I think that's fine.
Thank you. Commissioner Carruthers?
Mr. Chairman, Jeremy, you write in a footnote here, on June 22nd, 2021, the commission received a request for a formal advisory opinion that detailed the issues as presented herein. The request was submitted by a public official who has the authority to submit a request. Is there any particular reason why we're not identifying who asked for this opinion?
There is, Mr. Chair and Commissioner Carruthers, the who asked for formal advisory opinions under the State Ethics Commission Act is confidential. And not everyone in the state has the authority under the statute to request a formal opinion of this commission. And so we note where the opinion has been, asked by a person authorized to ask it. We note that they have, but we don't disclose the identity of the person, and under the statute that's kept confidential and it's not subject to IPRA or disclosure in the opinion or indeed at this meeting.
Mr. Chairman, Jeremy, my sense is that in the past, we've received these and they have had names on them. I recall one, I think a legislator asked a question and that legislator was identified. Is that correct?
Mr. Chair and Commissioner Carruthers, perhaps so in the context of an informal advisory opinion where we've issued a letter. There were letter opinions that were issued in this past session to individual legislators, but I don't believe that those were formal advisory opinions. But the law is that we're not supposed to do it in a formal advisory opinion.
Thank you.
Thank you. Commissioner Castillo? Anything?
There we go. I have the same concern that Stuart does. I agree. I like the idea of it saying "or" at the end of the opinion. And by the way, I agree that it's very well written. The only problem is at the very, very end, after the "or," there's a sentence that says, let me find it here. After the sentence, the conclusion, in the third line, it says, exercising the powers of a state agency's official acts or expending the agency's appropriated funds. And then the next sentence says that every state entity that receives an annual appropriation in Section 4 or the feed bill is a state agency. And I'm just concerned that reading that people might just use the last sentence and not really focus on the or, which means it's both.
Right, Chair and Commissioner Foy Castillo, this heuristic, the last sentence, every state entity that receives a Section 4 feed bill appropriation, the opinion and the commission would be using as a kind of shorthand for entities that that receive appropriated funds on an annual basis and therefore have to file a financial disclosure. I think that although I can't be certain, but I think that every entity that receives a Section 4 feed bill appropriation exercises some kind of power of the state, such that they alter the rights, duties, powers of other persons or other state agencies. But again, that last sentence in the conclusion, the kind of heuristic or kind of guide for who's receiving an annual appropriation in the major parts of the appropriation bills is again just a shorthand for that's the state entities that are state agencies because they annually receive appropriated funds and somebody at those agencies is responsible to expend them.
Okay, that makes sense. All right, thank you.
Thank you.
Thank you. Commissioner Solomon?
Well written. I don't have any questions, Mr. Chairman. Thank you.
Thank you. Commissioner Villanueva?
Well done, no questions.
Thank you. I
Thank you.
echo the sentiments of my colleagues. Very well done. I have no questions. Is there a motion to approve and issue this opinion?
To approve?
Is there a
Second.
second? Thank you. Moved and seconded. Commissioner Baker,
Move to approve.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes,
and chair votes yes. Thank you. Let the opinion issue. On to number 2. Walker, I believe that's yours.
Thank you, Chair and Commissioners. This is another interesting advisory opinion request, which I think is, going to form a piece of a wider conversation that the commission and other agencies involved in enforcement and also the legislature is going to have about the Campaign Reporting Act and regulation of the receipt and expenditure of donations to political committees. The request is pretty simple. It is, does the Campaign Reporting Act prohibit a candidate for an office covered by the Campaign Reporting Act from donating campaign funds to a candidate for a municipal, school board, or special district election? And the answer is no. And the reasoning for that is based largely on the text of section 29.1A of the Campaign Reporting Act. That section imposes restrictions on use of campaign funds. And I guess by way of a little bit of context, many are familiar with, as a general proposition, the fact that state law restricts the amount of contributions that may be received by candidates for statewide offices and legislative office. And it also requires reporting of contributions received. The Campaign Reporting Act also restricts what candidates can do with contributions received. And primarily, the primary restriction is that a candidate can only expend funds on expenses of the campaign. The candidate cannot expend funds for a purely personal use. There are other restrictions on the expenditure of contributions received, but the section that I just mentioned, 29.1, also says what the candidate may do with contributions received, and one of these sort of what the candidate may do is set out in paragraph 6, which is that a candidate subject to the CRA may take contributions received and donate them to a political committee or to a candidate seeking election to public office. And this is where the rubber meets the road, in this opinion. The Campaign Reporting Act defines election to be an election an election with candidates covered by the Campaign Reporting Act. But this particular paragraph 6 says election to public office. So it adds a kind of modifier to election. And the draft opinion interprets this provision as allowing a candidate to make a donation to a local municipal or school board election. So that reading is, I think, bolstered and I think made pretty unavoidable when you look at the context of that paragraph. In particular, if you look at the paragraph above, paragraph 5, that paragraph says that a contribution received may be used to eliminate the campaign debt of the candidate for the office sought or expenditures incurred by the candidate when seeking election to another public office covered by the Campaign Reporting Act. So the legislature clearly knows how to restrict the application of any provision here to only a candidate seeking office covered by the Campaign Reporting Act, and it did not use that phrasing in paragraph 6. And so the proposed conclusion is that the Campaign Reporting Act does allow a contribution to a candidate for a local municipal or school board election. Finally, I would note that this is a conclusion shared with the Attorney General's office. The Attorney General's office has issued 2 advisory opinions on this, reaching the same conclusion. This advisory opinion, adds a little bit further gloss on what the Attorney General's office has previously issued. And yeah, that's really all I have to offer on the draft advisory opinion. And I would seek I'd of course entertain any questions and then seek a motion to approve and issue the advisory opinion.
Thank you. Commissioner Baker, anything?
No questions.
Excuse me, Commissioner Bluestone?
Thank you, Mr. Chair, and again, well done, Walker. This is a well-written opinion also. I guess I have a couple of questions. One question is, if you read the term public office more expansively in that paragraph 6 than in the immediately preceding paragraph 5, are you then opening it up to federal offices in any state? And what about other public offices in other states?
So, Chair and Commissioner Bluestone, I think that the answer kind of flows from the discussion of local law. Local law allows these contributions. We note in the advisory opinion that the Albuquerque ordinances permit a candidate for the mayoral office to City of Albuquerque to receive contributions from pretty much any source. And so I think that you would, if you were asked to determine whether a candidate in another state could receive these contributions, I think the primary source of that answer would be state law and then perhaps federal law. I don't think that there are any federal laws governing the kind of interstate transmission of contributions, because my understanding is that there are plenty of contributions to candidates in New Mexico from folks who are, folks in political committees in other states. Now, the kind of follow-up question here, which is, well, what's the limiting purpose? Are we opening up a whole can of worms here? Are we permitting international contributions or something like that? I mean, that's sort of beyond the scope of the opinion. And I guess if the commission were to receive a request dealing with a specific fact pattern about a candidate or a committee in this state making contributions to a candidate or committee in another identified state, we could research that. And, there may even be federal laws that apply, but, for the purposes of the Campaign Reporting Act in this paragraph, I think the legislature's choice of a very broadly phrased to public office to modify election, especially in light of the previous paragraph restricting it to only office, restricting the use of contributions to retire the debt of the candidate seeking another office covered by the Campaign Reporting Act, I think motivates a broad interpretation of that provision.
Thank you. I'm also curious, did you find any precedent, any guidance that, in addition to the one you described, where if they use the term public office covered by the Campaign Reporting Act, and then immediately after it, just say public office, that means that it's not just limited to a public office covered by the Campaign Reporting Act. But similarly, is there any case law you found that says if you use a term like public office covered by the Campaign Reporting Act, and in the immediately succeeding paragraph, you just say public office, that implicitly that should be interpreted to mean public office also covered by the Campaign Reporting Act?
Chair and Commissioner Bluestone, off the top of my head, no. And in fact, as discussed in the opinion, I think that would, run the risk of rendering both those phrases sort of surplus and kind of, I want to say superfluous, because as noted in the opinion, the Campaign Reporting Act has an explicit definition of election and says in there that is an election. An election means any election covered by the Campaign Reporting Act, and that's the argument. To the extent there is a counter argument here, the argument stems from the definition of election, right? The term election is given an express meaning in the definitions section of the Campaign Reporting Act, and absent some further indication, that defined meaning would carry over to any other instance of the term election in the Campaign Reporting Act. However, as the Uniform Statutory Construction Act says, you do have to look at context, and you have to give, even a term that is expressly defined can have a different meaning if context strongly suggests that it has a different meaning. And so, I would think that the only way you could get to the conclusion that the term election in paragraph 6 of subsection 29.1a means an election covered by the Campaign Reporting Act is if the legislature did not include the modifier to public office after election, right? I mean, if paragraph 6 just said donations to a political committee or to another candidate seeking election, then the explicit definition would control. But if, because of the inclusion of these additional words, you'd have to disregard those additional words in order to get to the conclusion that it's only an office covered by the Campaign Reporting Act.
Thank you. I don't want to belabor this, and I'm fine with the result of the opinion insofar as allowing the funds to be used for local school board and municipal and other elections, as well as, I think you're explicitly stating in the footnote, federal offices, at least within New Mexico. But I still think there's some ambiguity with the issue, and it may come up again later, but I appreciate your explanations, and I thank you, Walker, for that.
Thank you, Commissioner.
Thank you. Commissioner Carruthers,
No questions.
Commissioner Castillo,
You're muted.
Celia?
Yes, here I am.
Okay,
Again, this is a well-written opinion, and I don't have any questions.
thank you. Commissioner Solomon?
Well written, no questions. Thank you.
Thank you. Commissioner Villanueva?
No questions.
Thanks. Chair has no questions. Is there a motion and a second?
To approval.
Thank you. Is there a second?
Second,
Thank you. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Mr. Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. The advisory opinion 2021-11 is to issue. Thank you. On to the next item. It's still your floor, Walker.
Thank you, Chair. And just as a matter of housekeeping, Jeremy, I see that the resolution here is on the page titled resolution number 8, but in the materials, file name is 2021-01. Which one are we going with for purpose?
We're gonna go with 2101. We probably need to begin to order the commission's resolutions by the year they were issued, since we're into a new year, more resolutions. Walker, before or as part of your presentation here, I'd like to screen share and show the commissioners what we've achieved on OneSource. For those commissioners that might not be familiar with OneSource and kind of how that relates to your resolution. So whenever is appropriate, just let me know and I'll share my screen. I've got OneSource ready.
All right, well, I'll add that we should recognize Becky's efforts in this respect. Becky has, I guess by way of context, and we'll go ahead and share the screen very soon. Becky has reached out to the New Mexico Compilation Commission, which is the authority responsible for publishing New Mexico Supreme Court opinions, Court of Appeals opinions, and New Mexico statutes annotated, and other authoritative sources of New Mexico law. I believe they now have a repository of the New Mexico Administrative Code. They also publish the New Mexico Rules Annotated, which govern proceedings in district courts, the Court of Appeals, the Supreme Court. It's the go-to source for New Mexico law, and as they call it OneSource. As the name indicates, it is the one source of New Mexico law that basically lawyers across the state use to look up statutes. It's a very useful tool. And Becky has been working with the New Mexico Compilation Commission to get our advisory opinions listed on the Compilation Commission's OneSource website. And I don't know if Becky has anything further to add, but she's really done a great job with interfacing with them and getting our opinions up on an official repository of New Mexico law. Becky, do you want to add anything?
I would just like to thank the New Mexico Compilation Commission, because they were so wonderful to work with. They were so willing and excited to have our opinions included, and they got it done very quickly when they had a lot of other things going on. They were launching a new website and working on the end of the year annotations on other things. So they were just fabulous and so excited to include us. So thank you to them.
Thanks, Becky. Well, Jeremy, why don't you go ahead and share the screen so the commissioners can see what our advisory opinions look like on the OneSource website.
All right, I'm sharing. Can you guys see?
Yep.
Yes.
All right, so this is New Mexico OneSource. Walker might have mentioned this, but it's free. State employees, in addition to members of the bar, use this every day.
I can only see half your screen right now for some reason.
How about now?
Now I can.
Okay, great. So the Ethics Commission's advisory opinions are here on the home page underneath the Attorney General opinions. You can click that and look at all the opinions we've issued.
That's great.
And because Cliff Reese is on the meeting as an attendee, I'm going to show another feature. So one interesting thing about OneSource is they do annotations to all the statutes based on New Mexico case law or Attorney General opinions, or now State Ethics Commission opinions. So if you go into the Procurement Code at Chapter 13, Article 1, and you scroll down to a relatively obscure provision of the Procurement Code relating to sole source contracts noticed and protest, 26.1, a provision rarely to be interpreted by an appellate court of law in New Mexico. That's okay, because the State Ethics Commission Advisory Opinion 2021-06 is there in the annotations interpreting the meaning and application of 13.1.126.1. And so as the commission issues its advisory opinions, and those go up on OneSource, they're added to the annotations of the statutory law. And this is a really important guidance function of the Ethics Commission. And I want to underscore, this is a real achievement, getting a body of advisory opinions and getting them on OneSource and the annotations will make a tangible difference in New Mexico. So thank you to the commission for these opinions and to Becky for pushing this with the compilation commission. And that, I think, leads up to the resolution about the official opinion.
Thank you. Thank you, Jeremy. So as you all have just seen, the OneSource website does a great job of showing all of our opinions in a list. It also allows the user to search those opinions for keywords, and the opinions are now starting to appear as annotations in relevant statutes. And in short, the New Mexico Compilation Commission is doing a better job of presenting the commission's advisory opinions than the commission could ever hope to do over the long term. And so what proposed resolution number 2021-01 does is basically set out that the official advisory opinion is going to be the advisory opinion that appears on the Compilation Commission website. It's not going to, the commission may put a PDF up in the meeting materials, and it may put a PDF on the website. It may put a PDF link on Twitter or something like that. But for the benefit of the public, any practitioners who might rely on our advisory opinions, this resolution is going to say that, if you want the official version, go to the Compilation Commission's website. And it's important for the commission to kind of set this out so that there's no, confusion about where the best place to find the commission's advisory opinions are. And it provides the commission staff with a short but detailed set of instructions about what to do when the commission issues an advisory opinion, to wit, take the advisory opinion and give an authenticated copy to the Compilation Commission for publication. So that's the resolution. I would entertain a motion to adopt the resolution under the title 2021-01, not resolution number 8, as is reflected in the resolution. That would be edited to correctly state the number of the resolution.
So moved.
Walker, you seek one. You seek one. The chair entertains one.
I apologize. I'm just parroting Judge Lang. I've got a 2-year-old who parrots me, and now I'm just parroting everyone else.
It's quite all right. You will probably hear it going the other direction sooner rather than later. So having gone through all that, there's a motion in the second, correct? Somebody say yes.
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 Thanks. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers.
Yes.
Mr. Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you. And that is pretty cool that that's on that site. That is not an insignificant thing for those of you who don't play the law research game. Okay. Next up is amendments to the joint powers agreements. And that is Jeremy's.
All right. So Chair and Commissioners, you'll remember our joint powers agreements. These were initially approved in December of 2019 when the commission was first laying out its initial crack at its jurisdiction and how to go about sharing that in a formal way with the Secretary of State's office. Those advisory opinions were the kind of guidance for about 1.5 years. The legislature amended the statutes that the commission shares jurisdiction with the Secretary of State for, the Campaign Reporting Act, the Financial Disclosure Act, the Lobbyist Regulation Act, and the Voter Action Act. The legislature amended those statutes in this past session in HB 244, which became effective on July the 1st. And with HB 244 becoming the law, we had to rewrite the joint powers agreements to make them align with the new statute. And so here you have before you the 4 draft joint powers agreements. These have been provisionally agreed to with the Secretary of State's office. The Secretary of State and I have yet to sign the agreements and submit them to DFA. which is what you do with joint powers agreements, but my hope is to do that after presenting these to the commission. I won't go through all the terms, but roughly what's going on is that these agreements should, following HB 244, very much streamline and clarify the process by which the commission and the Secretary of State's office handles the agency's respective responsibilities under the statutes. With respect to the adjudication of administrative complaints, the main changes are as follows. There's less of a kind of back and forth referral as compared to the initial agreements, and the terms are more clear, I think, on referrals. So with respect to administrative complaints that the State Ethics Commission receives, under the agreements for the Campaign Reporting Act and the Lobbyist Regulation Act, the commission refers those to the Secretary of State's office. The Secretary of State's office has either 35 days for a Campaign Reporting Act claim or 20 days for a Lobbyist Regulation Act claim to certify whether or not the respondent has voluntarily complied. And within that time period, after that time period elapses, if the Secretary of State's office has not certified voluntary compliance, the case is automatically back with the Ethics Commission and the commission's process moves forward. If the Secretary of State's office does certify voluntary compliance, then within the time period, then the commission dismisses those complaints. Part of, I think, the purpose of HB 244 and its amendments to these statutes and these joint powers agreements is that the Secretary of State's office is taking more of an administrative role with respect to handling filings under these statutes and trying to ensure voluntary compliance. And the State Ethics Commission is taking more of an investigatory and enforcement role and an adjudicatory role. With respect to the Financial Disclosure Act, one of HB 244's kind of larger changes is that all of the arbitration provisions that subjected a final decision by the State Ethics Commission to arbitration are now gone. And they're also gone from the joint powers agreements. And the last thing I'll mention with respect to, I guess, the Financial Disclosure Act, a joint powers agreement following HB 244 is that the commission does not have an obligation to refer a Financial Disclosure Act complaint to the Secretary of State's office. If there's a complaint alleging a Financial Disclosure Act violation, that's now purely within the commission's adjudicatory and enforcement power. With respect to the Voter Action Act, that's the statute in which the law has changed the least and the agreements have changed the least. It's still the case that for certification decisions under the Voter Action Act, meaning that a certification that a candidate who's able to receive public financing for their campaign, whether or not they've collected or met the minimum conditions for receiving public financing, certification decisions and appeals of certification decisions, that's still purely the Secretary of State's office. The only thing the Ethics Commission would really handle in terms of the Voter Action Act would be kind of complaints alleging violations of Section 7B of that act, which places limitations on what public finance dollars could be used on during a campaign and what they couldn't be used on. So with respect to the Voter Action Act, that's where the Ethics Commission is most likely to be involved. And that I'll remind the commission that the Voter Action Act has recently been expanded. It used to be public financing for the appellate judges and the PRC members. The PRC members will no longer be elected after recent changes in the law, and the Voter Action Act has been expanded to district court positions. So there's going to be a larger number of candidates seeking public financing, and perhaps the commission might see some Voter Action Act claims in the future about the expenditure of those funds. So that is a quick overview of these 4 agreements. In the agenda, Chair, that the agenda notes that commission action on these agreements is not required. But thinking about it, I actually would like to seek a motion from the commission, both to authorize me to enter these agreements, but more importantly, to authorize me to make referrals to the Secretary of State under these agreements, because these agreements are written between the commission and the Secretary of State's office. They say the commission will make the referrals, and I'd just like to have it on the record that the commission has authorized the director to do that ministerial work.
That seems the wiser course. Let's hear a motion in a second, and then I will turn it over for discussion. Is there a motion in a second?
So moved.
Second.
Thank you. Okay, Commissioner, any discussion? Let me ask, does anybody have any discussion, any questions?
I do have a question, Chair.
Yes, ma'am.
Jeremy, on page, on what you have as page 36,
Okay.
the blue pagination.
Mhm.
Not an attorney. I don't understand that sentence under 2C. Rules of procure. I don't know what that is. Is that a legal term?
No, that should be procedure, and I believe that is actually I believe the Secretary of State's office has already pointed that out to us, and it just didn't make it into these materials. So that's my apology. That should be procedure.
Anyone else?
Just want to commend Commissioner Villanueva on her eagle eye catch.
I wish I'd have had you the last couple of weeks. I had quite the thing to get out the door, and I really needed your expertise. You're the best proofreader ever in the history of proofreading.
Call me anytime. I have other small edits, but.
Anybody else? If not, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers. Uh-oh,
I think he's muted.
there he is.
Yes.
Thank you. I was worried about you there. I didn't see you. Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and Chair votes yes. Thank you, Jeremy. And commissioners. Okay, that leads to number 5, which is the special report on jurisdiction. Page 40, I believe.
Yes, sir. Okay. Commissioners, you'll remember that on October 1st, the commission owes the legislature and the governor a report on any recommendations regarding the expansion of the commission's jurisdiction. It's a project that the staff have been working on for months. And while I'm not providing the commission today with a draft of that report, I have prepared a letter for you, giving you a sense of where we're headed. And so this first, let me just clarify, this is about the commission's quasi-judicial power to adjudicate administrative complaints that are filed with the commission. And jurisdictional expansion can mean one of 2 things. It can mean expansion of the commission's subject matter jurisdiction, which statutes and constitutional provisions the commission has the power to adjudicate and issue remedies for. It can also mean, it also means and includes the commission's personal jurisdiction, what persons are within the reach of the commission's adjudicatory power. So breaking that apart, just to give you a heads up, the the draft that we'll be preparing for you will make recommendations that there be modest additions to the commission's subject matter jurisdiction for certain provisions of the New Mexico Constitution that are very much in the center of government ethics laws. Those are the Article 4, Section 28, which prohibits legislative interests in contracts. Article 5, Section 2, and Article 20, Section 9, those being constitutional provisions that relate to the emoluments of legislative office and extra compensation beyond salaries. The commission currently has subject matter jurisdiction for one provision of the New Mexico Constitution, namely the anti-donation clause. And it's an interesting grant of power. The anti-donation clause does have some relationship to government ethics, but I think that these provisions of the New Mexico Constitution are more within the center lane of government ethics law. And so that's where at the moment, I think the commission might benefit, and New Mexico might benefit from the commission having quasi-judicial power for those constitutional provisions. The commission indeed has already been asked for several advisory opinions that interpret the legislative interest in contracts clause in the Constitution. And so we think there is a kind of need for the commission to be involved in these provisions. With respect to the expansion or non-expansion of personal jurisdiction, what that topic is really concerned with is the expansion of the commission's personal jurisdiction to reach the officials and employees of local governments, county governments, municipal governments, special districts, school districts, for example. And where I'm headed at the moment is that at this juncture in the commission's life, I don't think it makes sense for the commission to recommend expansion of its personal jurisdiction to officials and employees of local governments for a few reasons. The first really is just related to resources. We can barely meet the mandates that we have, where we have 3 attorneys, we have a CFO, we have a communications director, and right now that's it. The contemplating expanding the commission's jurisdiction to allow any person to file a complaint against an official or employee of a county or municipal government would just require a very large increase in the staff, and we don't have the staff currently that we have to handle the commission's current mandates. And so I just very much doubt that there would be an appropriation that would be equal to the expansion of this jurisdiction. Relatedly, in the FY23 budget request, I'll be presenting to the commission a budget that requests an appropriation that gets us back to the FY21 appropriation, which is 6 employees as opposed to 5, but also asks for 2 additional personnel positions, one being a paralegal, the other being a kind of IT database position. And the position kind of that we'd be seeking, that we had in FY21 and would be seeking again in FY23, the exempt special projects coordinator position, I'd hope to use to hire a kind of a special counsel, another attorney into the commission staff. So the first reason, the predominant reason for advising against a recommendation for an expansion of jurisdiction to locals is resources. The second is the commission already has a number of important roles with respect to local governments. the commission offers trainings to local governments. Indeed, in the fall, we'll be both at the annual conference of New Mexico counties and at the Municipal League's Annual Leadership Institute, offering trainings on the state's ethics laws. We've offered trainings to county commissions in the past. That's something that we currently are tasked to do and have the authority to do, and in fact do. Second, while the commission doesn't have the power to adjudicate an administrative complaint filed with the commission, the State Ethics Commission does have the authority to file in state district court a civil enforcement action to remedy the civil provisions of the Governmental Conduct Act and the Procurement Code. Those are the two ethics statutes that mainly apply to local governments. To some extent, the Campaign Reporting Act applies to certain county elected offices, but not municipal offices. And the commission also has the power to initiate civil enforcement actions under the Campaign Reporting Act. And so if there is an appropriate case where the commission needs to exercise its power to remedy a violation of the Procurement Code or the Governmental Conduct Act at the local level, the commission currently has the authority under those statutes to do that. Third, the Attorney General's office is already active in this area. They bring criminal prosecutions under the Governmental Conduct Act and the Procurement Code against local actors. And and to commend the current Attorney General and the Office of the Attorney General, they've been doing that recently in cases that have appeared in the papers over the past month with respect to the ethics provisions of the Procurement Code, the disclosure provisions of the Procurement Code, and the Governmental Conduct Act. And so that lessens that an active Attorney General on these statutes with respect to local governments, I think to some extent lessens the need for an administrative agency adjudicating administrative complaints against local officials under those statutes. Next, several of the larger local governments, county governments and municipal governments already have their own ethics boards and their own ethics ordinances that to some extent regulate conduct that overlaps in ways that the Procurement Code or the Governmental Conduct Act regulates that conduct. So the city of Albuquerque has a board of ethics, as does the city of Santa Fe, as does Bernalillo County, Sandoval County, Santa Fe County. So for the larger local governments in the state, they have their own ethics ordinances that to some extent align with or go beyond the Governmental Conduct Act or the Procurement Code, and they are adjudicated locally. To extend the commission's quasi-judicial power for officials and employees of those local governments, I think invites a kind of jurisdictional quagmire. Folks will begin to ask, well, I have an ethics complaint. Do I file it in the Albuquerque Board of Ethics? Do I file it in the State Ethics Commission? And then that forces us to say, well, are you alleging a violation of a local ordinance? Are you alleging a violation of a state statute? That expansion of jurisdiction kind of invites those issues that would have to be teased out, and it wouldn't be all that easy. That's the kind of broad set of reasons why I don't know that it makes sense right now for the commission to recommend this and to push for this. If there's one thing I think that the commission could do with respect to local governments, and this relates to Governor Carruthers' question a little earlier, I think it would benefit the states and local officials and employees to enable those persons to ask the State Ethics Commission for an advisory opinion and to change the Ethics Commission Act in that way, expanding the universe of who's permitted to ask for advisory opinions. That's a function that other states that have jurisdiction for local governments have, and I suppose finally, I'll close by noting that I've spoken with the directors of about 20 to 24 other states that have jurisdiction both for state officials and for local officials. And they almost uniformly say that the local, the jurisdiction for locals is some of the most rewarding and important work that they do. That in many cases, the locals just don't have the same kind of resources as state agencies, and they think that they're really adding value there. And I don't dispute that at all. And I don't think that that one day the State Ethics Commission couldn't provide real value to local governments in allowing for an expansion of its quasi-judicial power. But I think the commission could get a lot of that benefit just by expanding the ability for who can ask for an advisory opinion to cover local governments, special districts, school districts. And so, Chair, that's the preview of where we're headed based on the research that we've done, which has included surveys to local governments, interviews with the directors of other state ethics commissions, and just a sober assessment of kind of where we are now with the resource constraints we're currently under.
Thank you. Let's go around the room. Jeff, do you have anything?
I have one question. At the bottom of page 40, which is the first page of the letter, Jeremy said the only extension of the commission's jurisdiction I currently recommend is an extension of subject matter jurisdiction to adjudicate complaints with respect to legislators' interests in contracts. Remind me, if our jurisdiction is expanded to include that, what are the possible penalties if the commission finds that a legislator has violated an interest in contracts provision?
Chair and Commissioner Baker, I'm sitting here this minute. I'm not sure on what the remedial provisions beyond a recommendation to that chamber for discipline that chamber could issue. Beyond that, I'm not certain that there are additional remedies without researching it.
Yeah, that's fine. I just want to make sure that if we're going to go to the effort to adjudicate whether a legislator has violated that provision, that there ought to be a consequence that has enough sting to it to have made the work appropriate.
Chair and Commissioner Baker, I mean, one thing that is missing from the State Ethics Commission Act is a provision that gives the commission remedial power to issue appropriate relief, injunctive relief orders, et cetera. I mean, that's something that Walker and Becky and I have noticed in other contexts. And so perhaps as a recommendation for the expansion of subject matter jurisdiction, I mean, one thing that might need to be added along the way in terms of statutory amendments is a remedial provision in the State Ethics Commission Act that gives the Ethics Commission a statutory basis for enforcing its decisions.
Thank you. And just one more comment. I appreciate the concern about overlapping jurisdiction, that if a city, a county already has an ethics commission, already has a mechanism in place to receive complaints and adjudicate them, it might be down the road when you have enough staff that the Ethics Commission would occupy that space where local government does not have its own ethics commission, so that there wouldn't be that competing jurisdiction that you mentioned earlier.
Well, that would be a large change, for the legislature to divest the locals of the ability to enact their own ethics ordinances and to adjudicate violations of their own ethics ordinances.
No, what I'm suggesting is if, for example, Roswell has an ethics commission, but Hobbs does not, in the absence of an ethics commission in Hobbs, the state ethics commission could fill that space. Just an idea.
Correct.
Thank you. Stuart?
Thank you. Again, well done, Jeremy. I think it's a reasonable approach you're outlining. I have a few questions. In terms of our personal jurisdiction, it seems like most of the complaints that we've dismissed have been because we don't have jurisdiction over the state entities and only have jurisdiction over the state officials and employees. And I wonder what your thoughts are on whether we should seek jurisdiction over the entities as well.
Chair, Commissioner Blueston, that's a really interesting question. I'd like to think about it before I gave you an answer now. It in part, my hesitancy and reticence in part relates to the need to think through whether or not the substantive provisions of the Procurement Code and the Governmental Conduct Act apply themselves to the organizational entities of the state, or whether or not they really only apply to the officials and employees of the state entity. But I'm marking that down as something to think about with respect to expansion of personal jurisdiction.
Thank you. A second issue on our subject matter jurisdiction is it's always struck me as a little odd that the legislature gave us authority over the anti-donation clause. And I wonder if you could comment on whether we've actually had any work involving the anti-donation clause, if you think it's really more of a legal issue that belongs in the Attorney General's office rather than an ethics issue, and just what your thoughts are about whether we ought to consider revisiting the grant of jurisdiction over that particular provision.
The Chair and Commissioner Blueston, we've had an administrative complaint that was purely an anti-donation clause complaint. It related to an important matter in the state. And I think the legal analysis that Walker did in the recommendation on the motion to dismiss and the hearing officer's order on the motion to dismiss in that case clarified the anti-donation clause case law. The anti-donation clause has a range of proponents and opponents in the state. My view is that the anti-donation clause remains an important constitutional provision that constrains state agencies and state officials in important ways that are also ethical ways. I think that the anti-donation clause prohibits the kind of leaking of funds that are appropriated to state agencies to entities and persons outside of the state and outside of the normal process of expending state funds. I do characterize the anti-donation clause as a kind of anti-corruption law. It has anti-corruption purposes in its own way. It is an artifact. It's a clause that very much relates to the corruption that surrounded the expansion of railroads in the Midwest and the West, and it in some ways, it can be argued that it's quite outdated, that the anti-donation clause is no longer fitting for an economy in which state government, it plays an integral role in promoting and subsidizing industry in the state and trying to promote economic development in the state. But
Thank you.
Well, let me just finish. That's been addressed through amendments to the anti-donation clause that allowed for LEDA. And I think the residuum is still an important anti-corruption law that has a place with the Ethics Commission.
That makes sense. Thank you. I know that your focus of your memorandum is on whether to expand personal or subject matter jurisdiction, but since you also refer to the problem with small fines for penalties for violations and the incentive of officials and their lawyers to then just keep litigating really ad nauseum, are you intending to be recommending increases in some of these penalty provisions when we get later on to consider a range of amendments we might propose on ethics laws to the legislature?
So Chair and Commissioner Blueston, I definitely believe that the remedial provisions of the ethics laws is an area that the commission should look at. I know that several of the advocacy groups are beginning to have discussions related to whether or not the remedial provisions in the ethics laws are sufficient to provide the deterrence they need to provide. And I plan to follow those discussions and report to the commission on kind of where the non-state groups are thinking, and encourage the commissioners to think about those remedial provisions too. I think this is a conversation that the commission should have in the lead up to the future sessions.
Good. And then the reference you just made about in response to Governor Carruthers' interest in expanding the universe of officials who could request advisory opinions, do you then intend to include that in a more final memorandum that you present to us?
I do.
And then I just want Commissioner Villanueva to know that I did find a typo that I told you about.
Do you want to share it with us?
No.
Yeah.
Chair, it's a demanding commission. We produce a lot of legal work, and it's good to know that whenever we slip, it will be caught.
Yes, it will.
Commissioner Bluestone, is it the period that was missed on page 41?
No, Commissioner Villanueva, it is not. That one is entirely yours to catch. Mine was simply on page 41, the lines 2 and 3, where it repeated the phrase "and not to obtain personal benefits."
Very good.
I'll get a gold star from you next time I see you.
Thank you both. Commissioner Carruthers.
I think you could ask people who voted for the constitutional amendment to establish the Ethics Commission, that most of them, if they could remember voting for it, would suggest that they probably were more interested in what was happening in their local lives with the community, the school boards, those kinds of things. I'm not sure they were focusing much on the current event that we have right now in our state legislature with a perhaps not only ethical but illegal sayings. That I don't think local people focus a whole lot on that. They're more worried about what their county commission is doing, what their city council is doing. So from a perception point of view, I believe they believe that the Ethics Commission is here to serve their needs locally and not so much worrying about employees in Santa Fe. Just a comment. Now, we don't have the resources to expand the jurisdiction, but I think in our long-term plan that we ought to look into what is the best path to do that. And I'm not sure I can give you any good recommendations. I'm not sure that I would be in the camp of wanting to take it over for the whole state. But let me give you an example of what might happen. Albuquerque has their own ethics commission and apparatus. But let's assume for some reason it's such a sensitive issue that they'd want to change in venue, that they believe maybe this ought to be better handled maybe by the State Ethics Commission as opposed to handling it locally for whatever reason. Maybe it's the personalities involved or whatever. There might need to be provisions where occasionally the State Ethics Commission does handle complaints from outside simply because they don't have the ability to do it internally, or for some reason they believe a change in venue might be in order. So as you're going down a road planning, today's not the day to do a whole lot of that. You don't have the money to do it, and you're not going to get the money to do it in the near term. But I'm still concerned that we're not serving, in my view, the people who said aye when it was on the ballot. I believe in their mindsets, they were more concerned about the local issues than they were state issues.
Thank you. Commissioner Castillo?
I don't have any comments on this. I'm learning my way through, and I think that the report is thorough, and yes, we need to continue looking at what the subject matter and personal jurisdiction is about. And I agree that allowing more people to ask for advisory opinions could go ahead and help in the future in areas that cause questions as far as the state is concerned.
Thank you. Commissioner Solomon?
Thank you, Mr. Chairman, and thank you again for the opinion or for this analysis, Jeremy. I was just wondering, in terms of the subject matter jurisdiction area, if we're contemplating also looking at allegations or complaints of malfeasance, which is kind of that's been litigated under our state court system in different cases. But are we sort of migrating, or would we be migrating into that area, or what kind of barriers are we going to set so that we don't cross over? Thank you.
Chair and Commissioner Solomon, I don't think that with respect to government malfeasance, in my view, that kind of concept overlaps a little bit with the provisions of Section 3A and D of the Governmental Conduct Act. And the commission currently has jurisdiction for the civil remedies under those statutes. Certainly if malfeasance is knowing and willful, it becomes criminal and is within the Attorney General's discretionary power to prosecute. But nothing in this report or in the recommendations I would present to the commission for its report in October would any way change the commission's jurisdiction for Section 3 of the Governmental Conduct Act. That's very much in the main line of the commission's work, and I think always will be.
Thank you. Commissioner Villanueva?
Thank you. Jeremy, first of all, I appreciate the fact, I appreciate you informing us of where you're headed on this issue. I want to note that I'm kind of thinking about what Governor Carruthers has mentioned, and also Governor Bluestone with respect to the number of complaints that we've actually responded to with the response of no jurisdiction. I think that's caused a lot of disappointment with many of the voters who had greater expectations. I just want to make a comment, an organizational one, from a different perspective from the world that I come from. I would hate to miss this opportunity to expand our jurisdiction only because it's come up. And if we were to walk away from it now, who knows when it will come up, the opportunity will come up again. I think we agree that this is not, that this is, that the expansion itself is needed. Your initial response to whether or not we should pursue the expansion was a lack of resources. Now, in the world that I came from, that would not be a reason to not accept that function. Organizationally, ethics is the function of the Ethics Commission, and in an organization outside of government, we would accept the responsibility, but when we write out our strategic goals and plans in the mission, you would simply say either you're not going to fund that portion, that particular function, because you lack the resources. And on the other hand, maybe we could accept the expansion at this point, or pursue the expansion. And just as we do with prioritizing informal and advisory opinions, we can prioritize which activities we would pursue. But I'm not suggesting that you change your opinion. I just kind of want to throw that as a comment that there are many things that we are tasked to do that we don't have resources for, and that exists also in many other agencies, and so those things just don't get done. So just want to kind of throw that out.
Chair and Commissioner Villanueva, thank you for those comments. I want to emphasize again, because I feel like this point is not hitting, and I want to try to get it to hit. The commission can very much respond to local concerns about ethics violations through its discretionary power to file lawsuits, not complainant versus respondent, adjudicated by the State Ethics Commission, that kind of turns our adjudicatory process, but rather the discretionary power, where the commission is informed of an issue at the local level, thinks that a lawsuit is the right response, and authorizes the attorney staff to go forward on a procurement code or a governmental conduct act violation. And when the commission has yet to do that, the commission has only done that with respect to the Campaign Reporting Act. But in an appropriate case where the State Ethics Commission files a lawsuit about a local issue, I think that's going to resound in the public's view of the commission, responding to violations at the local level, ethics issues at the local level, and should shore up some of the concerns that both Commissioners Villanueva and Carruthers mentioned. The adjudication of administrative complaints is a less efficient way to vindicate these statutes than the discretionary filing of lawsuits for the following reason. Complainants, anybody can file an administrative complaint, and what they file, what they allege, it might not actually satisfy the elements of a violation. And in many cases, they don't know, because they're pro se and they're not lawyers. They don't even know if their complaint is within the commission's jurisdiction as provided by the State Ethics Commission Act. They just file complaints. And then the staff has to sort out, is this complaint within the jurisdiction? Does it minimally satisfy the elements of a violation? And all of that sorting, that's a large part of what Walker and Becky and I do before it ever gets to a point where Walker's doing an investigation, Becky's doing an investigation, and we're actually getting into vindicating the statutes. It's just much less efficient a way of vindicating these statutes and the ethics concerns than the commission being informed of a violation and using its discretion to go forward with a civil action. And again, the commission has that power now with respect to locals, and it has since July 1st, 2019. It's just a matter of using it.
Um, I may be incorrect on this, but Commissioner Baker had mentioned the thought or the suggestion that perhaps we could assist communities that don't have any kind of ethics oversight. I recall the gentleman we had on, I believe he was the mayor of Escondido.
Espanola.
Espanola, who came before us, and we sent him away with empty hands. So if we were to expand our jurisdiction, just as Commissioner Baker had suggested, maybe we can fill those areas where they have none. But we first have to have an expanded jurisdiction. Again, not lobbying either way. I just kind of wanted to throw that out.
Thank you. I have nothing further. Anybody have anything else? Okay, thanks, Jeremy. All right. Want to take a short break, or should we go through the next bit? It seems like a logical place to do it because we're moving into rulemaking, which is usually a bit more deliberative. So what's the pleasure?
Take a break.
5 minutes. All right. See you in 5.
Thank you.
All right. Everybody back, ready to go?
Yes, sir.
The enthusiasm is just deafening. All right. Next item is I'm reading it directly from the agenda, the begging of public rule hearing. Judy, I caught that one myself. I suggest to you it is supposed to read beginning of public rule hearing. So with that, Ferris and Boyd, LLC, take it away.
Not quite yet. So Chair and Commissioners, what you have before you are rules that the Commission issued for public comment at its last meeting relating to amendments to 1.8.1 and 1.8.3 of the Administrative Code. I'd like Walker to just run through the steps that the Commission took to notice these rules for this rule hearing, and then to advise us if we've received any public comment.
Thank you, Jeremy. After the commission voted to issue the proposed rules for public comment, we published a notice of this rule hearing in the New Mexico Register, volume 32, issue 12, which was published on June 22nd, 2021. The notice contained instructions for how to access the proposed rules on the commission website. It also explained the commission would be having a hearing today where public comment would be accepted. It also provided a deadline for submitting written comments, which I believe was close of business on Wednesday, August 11th. The commission posted the notice on its website. The notice was also published on the New Mexico Sunshine Portal. The proposed rules are available at our offices, and we have sent out an email blast to everyone who signed up for updates on the commission's developments with the commission. We've not received any requests, but we're ready to provide a copy of the rules on request. And I emailed the notice to the New Mexico Legislative Council for distribution to the appropriate interim and standing legislative committees. And I do not believe that the commission has received any written comments. I checked the commission's email account just now. I did not see any written comments come in. I would ask Jeremy or Sunny to chime in if any written comments came in the mail. I haven't been checking the snail mail.
They have not.
And so, yeah, there have been no written comments, which is understandable given that the proposed rules are largely tweaks to the existing rules.
Okay. So then I suppose we move on to number 7, which is the public comment, which is a slightly different beast.
Well, according to, I don't know if I'm jumping out of turn here, Jeremy, but I think we can have a period for presenting the rules, and then yes, we can go to.
I'm sorry, I'm ahead of myself. Yeah. Go ahead.
So, yeah, there is a place on the agenda for the commission staff just to remind the commissioners and the members of the public what's in these rules. Walker and I will break that up. I'll start with 1.8.1 and some changes that the commission has noticed with respect to advisory opinions. The most significant of which is allowing any commissioner to request the staff to prepare a formal advisory opinion based on some legal work that the commission staff has done in the context of an administrative case. For me, this is an important amendment because we're doing a lot of clarification of the law and legal work in administrative cases that the public doesn't have access to because the materials remain confidential, either because the commission dismisses the complaint for lack of jurisdiction or a hearing officer dismisses it because the complaint fails to state a claim. But along the route to those depositions, there's some important work being done to clarify the law. And when that happens, this rule amendment allows a commissioner to point that out, to ask the staff to prepare a formal opinion that scrubs the identifying information from that material, and to present it to the commission as an advisory opinion. So that I think is a rule amendment that will kind of further help the commission's clarification of the ethics laws. And then moving on to 1.8.3, there are several amendments to these rules. We reviewed them in the last meeting, but just to remind the commission and members of the public, some of these changes were required by HB 244, such as the excision of the notarization requirement for complaints filed with the State Ethics Commission. Other of the amendments align the commission's adjudicatory process with the commission's proceedings portal, its web-based case management and docketing system. Other of the amendments relate to the commission's ability to initiate administrative complaints itself, which I know will be an issue that will come up for discussion after the rule hearing. Other of the amendments try to streamline and make more efficient the process by which administrative complaints are reviewed and adjudicated before the general counsel commences an investigation. These amendments try to strip out some of the motions practice that we think is maybe a bit overwrought in the current rules of procedure. And then there are other amendments that address the general counsel's investigatory powers and as it relates to subpoenas and otherwise, that I'd like Walker to briefly review before we go to public comment.
Thank you, Jeremy. The main change to be observed is, as Jeremy noticed, Jeremy noted, the removal of provisions dealing with the motions to dismiss. We're getting rid of the process, or we're proposing to get rid of the process whereby a respondent to a complaint alleges that a complaint fails to state a claim, and then we have a bunch of motions practice from lawyers. The new rules create a more streamlined process that allows the general counsel to request a response if the general counsel deems it necessary to sort of understand the merits of the complaint. You can ask the respondent to respond to the allegations in the complaint, but the response is not necessary, and the investigation can proceed to a final determination of probable cause much more quickly. So the commission staff is not being bogged down by motions practice. The changes to the investigation process are sort of too numerous to really cover, but they kind of fill in gaps that have either come up just to the commission as part of the process of investigating these complaints, or been identified by parties to administrative complaints. So, for example, at one point, a party noticed that the provisions dealing with discovery allowed the general counsel to propound requests for documents on any party to a case. And, a kind of objection was made. Well, if you're not a party to a case, we don't have to respond to your requests. And of course that, we feel that that's not really a correct reading of the rules, but these rules kind of clarify that and make it much more straightforward that the general counsel can request documents from anyone. You don't have to be a party to the case. So that's just one example. And there are other changes throughout that really are just by way of clarification of the existing rules. And there's a reorganization too. There's now a kind of dedicated section 1.8.3.12 that deals with enforcement or subpoenas and enforcement of subpoenas. This kind of fleshes out what's in the statute, section 10, 16, 10, in particular J, but also I of that section. And that is probably the largest bit of new material you'll see in the rules. And that just kind of sets forth the basic process for how the commission is going to issue, serve, and seek to enforce subpoenas. Finally, there is a provision for summary disposition by a hearing officer. That just, I think that power probably already existed under our current rules, but it's just clarified that if, when a case goes to a hearing, if the facts are undisputed, the hearing officer can issue a written decision on that, and doesn't need to convene a hearing necessarily. That's really it. I have nothing further to add on that short presentation, and yeah, I think we should proceed to the next agenda item unless there are questions about the proposed rules.
My preference, if it's okay with the rest of the commission, is to entertain the public comments and then turn it over to the commission. And unless anybody has a strong feeling otherwise, why don't we proceed in that vein? Go ahead, Walker.
All right, so for those folks, members of the public who are here to make a comment, I would ask that you use the raise your hand function in Zoom to signal your desire to make a comment, and then I will go ahead and recognize folks who raise their hand. And I think for the folks who are on the phone, we've got one person attending by phone. You need to press *9 on your handset in order to raise your hand. Anyone want to make comment on these proposed rules? All right, we've got one person. We've got the person who's attending by phone number 505-507-2779. I'm going to ask you to unmute yourself and please identify yourself to the commissioners before offering your public comment.
Hello. Can you hear me?
Yes, we can.
Okay, my name is Brody Norton. I have a question about the determinations of no jurisdiction, either by the SEC or by council. Are those complaints made public?
Chair and Mr. Norton, while we don't normally entertain questions during public comment, I'm happy to answer this one. It's an easy one. The answer is unless the general counsel finds probable cause in an administrative case, the case materials are not made public. So if a member of the public files a complaint with the State Ethics Commission that the commission doesn't have jurisdiction for, what happens is the respondent is notified that the complaint has been filed against them, but that complaint is not available to the public.
Okay, thank you for clarifying the rules and for answering my question. That is all.
Thank you. All right. Next to raise their hand is Mr. Tony Ortiz. Mr. Ortiz, would you like to make a public comment?
Yes, thank you, Walker. And I would just note that embedded in the proposed changes are measures that would streamline the case flow for administrative complaints. And that seems particularly important given the resource challenges that were discussed earlier in the meeting. So if those are adopted, and if they indeed actually make it easier, more efficient to move cases through the process, that's a positive thing. Thank you.
Thank you, Mr. Ortiz. Chair, I'm not seeing any of their hands raised.
Okay. Well, let's check on the commissioners then. Commissioner Baker.
No questions?
Thank you. Commissioner Bluestone.
No questions. Everything looks good. Thank you.
Thank you. Commissioner Carruthers.
No questions.
Commissioner Castillo.
No questions.
Thank you, Commissioner Solomon.
No questions.
Thank you, Commissioner Villanueva. Judy?
Okay.
There you go. Judy, do you have anything?
Yes, Chairman, thank you. Director, in 1.8.1.9, I have a question on advisory opinions and informal advisory opinions. In B5, it states if a person submits a request for an advisory opinion and does not specify whether the request is for a formal advisory opinion or an informal advisory opinion, the director or the director's designee may answer the request through an informal advisory opinion. The director may also relay the request to the commission to issue a formal advisory opinion. First of all, I don't understand why we just don't ask the person whether they're seeking a formal and an informal, or rather than an informal. But I don't know if there is a designation of formal advisory opinion, because in section A2, it states upon receiving a request for an advisory opinion, the commission must provide the requester, et cetera, et cetera. And we treat that as a advisory opinion, not a formal advisory opinion. Whereas as in B5, if an individual submits a request for an advisory opinion, would that not be, would not the default be formal advisory opinion?
Chair and Commissioner Villanueva, I think you're correct. The word formal is probably surplus there, but yeah, if you'd like it removed, we'd be happy to do that.
Okay, so, but if an individual does not indicate whether it is formal or informal, and they simply say advisory opinion, wouldn't it be a formal advisory opinion anyway? So the decision, there would be no decision to make.
Chair and Commissioner Villanueva, I take your point. I think the purpose here is to try to enable the commission staff to issue informal advisory letters. Maybe even as a kind of preference over formal advisory opinions. I think as the commission grows and in its years to come, these informal advisory letters that the commission staff turns around will be an effective way of answering ethics complaints quickly without kind of waiting for the commission to meet. And because the commission's formal advisory opinions are now on one source and kind of more open to the public's view, I think the commission just will need to be correspondingly kind of more careful with what opinions it issues as formal opinions, knowing that they'll be posted on one source forever. So I suppose that that there might need to be some language changes here to try to I guess effectuate that purpose, because you're pointing out that just a request for an advisory opinion might be able to be interpreted under the rules as an automatic request for a formal opinion, and that's not what we mean.
Okay, very good. Thank you.
Thank you.
Will you be submitting some more language to us?
Well, Chair, if we are on number 8, adoption of amendments to 1.8.1,
yeah,
you know, we either could work it out now, or we wait 2 months to issue the rule and work it out then.
Can I just shop a potential change here and see if that maybe addresses Commissioner Villanueva's concern? And that would be to just delete from the second line there on B5, delete the words formal advisory or a formal advisory opinion, or, so that the subsection B5 would now read, if a person submits a request for an advisory opinion and does not specify whether the request is for an informal advisory opinion, the director or director's designee may answer the request through an informal advisory opinion. And I guess by way of further explanation, that would kind of harmonize with the existing rules, which allow the director to take an informal advisory opinion and then convert it into a formal advisory opinion for consideration by the full commission.
So are you saying then, by changing that language, would it mean that if a requester were to submit a request for, not submit a request for an informal, that you would give him an informal?
At the change would be at the director's, would make it to the executive director's discretion as to how to answer it. So I can say through experience that the staff gets a number of requests that specifically state I am requesting an informal advisory opinion. That's common. And then there are some requests that come in as just we're requesting an advisory opinion. And so, for example, the two opinions that the commission issued today were just a request for an advisory opinion, and Jeremy did not elect to issue an informal advisory opinion in response to those two requests and then convert them over. The staff just went ahead and drafted those two opinions for the commission to consider directly. And that would still be permitted under this process. It's just that this rule change would allow the executive director to go ahead and answer it as an informal advisory opinion within a couple of days, and then make the decision later about whether it should be presented as a formal, or I guess proper advisory opinion to the commission as a whole. Jeremy, I may have missed something there, but
No, you got it.
Okay, so in other words, a request for an advisory opinion that does not state informal advisory opinion can, at the discretion of the director, be responded to as an informal advisory opinion? If it doesn't say, but if it does not say they're looking for an informal, then they are looking for a formal.
That might be so, Commissioner Villanueva, but I think again the goal that Walker's language is trying to effectuate is the commission, now that these opinions are going up on one source, the commission needs to be in control of what is a formal advisory opinion that's published on one source. And if it's a very small question, then even if the request doesn't state it's requesting an informal advisory opinion, it might be best to treat it as such and answer a small question in a letter opinion, turn that around in a day or two and move on without going through the process of an agenda item and publication on one source, et cetera. The question might not merit that kind of treatment.
I'm looking at it from the perspective of the requester. I thought when we started these discussions that we felt that it was a great benefit to individuals who might need the information, and I still do believe it's a great service. But there are differences between the formal, and as we say formal, and the informal advisory opinion. And I'm not an attorney, but I would say that the legal reliability would be one issue for the opinion to be used in a legal argument. And I think also the applicability of the opinion to be used in a general way versus a specific way. And I would think that that should be left up to the requester. So why don't we just simply ask the requester if they're seeking an advisory opinion versus an informal advisory opinion? I know that the resources of time are short, but I think by asking the requester, we minimize the chance of missing the mark of what they're actually needing. And
That's true. They might be trying to prepare some type of defense to a complaint. And so would be requesting a formal opinion to try to prepare a defense. The counter argument is the commission really ought to retain some amount of control as to what is issued as a formal opinion. But Commissioner Villanueva, I take your point that there could be persons who fear being named as respondents to ethics complaints that want to go ahead and try to head that off, request a formal opinion, get an opinion issued that's binding in a future administrative proceeding. And that's a kind of an interest that the commission really should honor. And so Commissioner Villanueva, are you proposing language be added to B5 that if a person submits a request that doesn't specify, that the staff try to clarify the nature of the request before moving forward?
I don't even see that there should be a need for B5. They either request a formal or an informal, and you treat it as such.
Okay.
And perhaps I think in a discussion that we had, that I think the commission has already had the discussion as to how to prioritize those, and it would be with respect to the resources that you have of time and staff. So that's really left to your discretion already. Isn't that correct?
Yes, ma'am. So Commissioner Villanueva, are you making a motion to strike B5 then?
Would it be a substantive change to you operationally?
I don't think so.
Okay, I'd make a motion to strike B5.
There a second?
Second.
Okay. Circling back, Judy, do you have any, no, let's deal with the motion. Anybody want to discuss anything further on the motion before calling a vote?
Yes, I have a question.
Yep.
I appreciate, I think, the interest in trying to respond as quickly as possible to requests for advisory opinions. And that's the advantage of using the informal advisory opinion route. I know that there have been chronic complaints for years about how long the Attorney General's office has taken in issuing its opinions. And I think it's been really helpful to the public that the Ethics Commission has been able to issue these informal advisory opinions very promptly. And so I think, while I appreciate what Commissioner Villanueva is proposing, to look out for the interest of the person who's actually making the request, I'd still like to play with the language a little bit so that that person can submit a request for an opinion, not specify whether it's informal or formal, let the director still have the discretion to answer it as an informal advisory opinion, so that it can get out promptly and satisfy the interest of the requester in getting a quick response, and then leave it up to either the requester or the director to relay it as a request for a formal advisory opinion later. So what I'd like to see is a little bit more flexibility so that as the requests come in, the director has the option of treating it in a prompt way with an informal advisory opinion response in a day or two, but that still leave the option open after that for both the person who made the request and the director to still have it be submitted to the full commission later for a formal advisory opinion. And I'm not sure that by just deleting B5, that option is still preserved.
Anyone else?
I understand.
Yeah, I got a question.
Chairman?
Go ahead, Jeff.
Stuart, are you suggesting that all requests be treated as requests for informal advisory opinions? Those will then be responded to, and after the informal has been issued, that either the commission or the requester can say, you know what, I'd really like this to become a formal opinion?
No, I wouldn't phrase it that way, Jeff. The way I'd phrase it is that if it's not specified one way or the other, yes, it is a request under the statute for a formal advisory written opinion. But that we should build into our rules, which I think we have the authority to do, the flexibility of responding quicker than through a formal advisory opinion with the option, but leaving it up to the discretion of the director about doing an informal advisory opinion in order to get a quick response out to the public and to the person who's interested. And then if that doesn't satisfy the requester, they can still put in a request for a formal written commission opinion, but it may be enough that they get the written response right away from the director or his designee. So I don't know if I'm being clear, but I'm trying to provide more flexibility for both the requester and the director and still preserving the option of quick responses.
Well, let me, if I can, I work best with concrete or quasi-concrete examples. Hypothetically, the governor wants to have her daughter do her makeup and hair, and she wants a quick opinion on whether she can use campaign funds to have her daughter do the makeup and hair. She calls Jeremy and she says, Jeremy, can I get an opinion within the next 48 hours? And Jeremy says, yes, Governor, I can do that. And then Jeremy gives a 48-hour opinion. That is an informal opinion. Is that available to the public? I assume that the governor can say, hey, I got an opinion, Jeremy says X. And what you're saying is that if the governor after then wants Jeremy's opinion to become a formal opinion, she can then request that it be made formal. And then 2 months later, a formal opinion will be issued.
I think that's exactly right.
Okay.
But the request is confidential when it's initially submitted.
But if hypothetically the governor gets Jeremy saying, yep, Governor, it's okay for your daughter to do your hair and makeup, the governor is free to then give that to the press if there are any inquiries.
So Chair and Commissioners Bluestone, Villanueva, and Baker, if I could suggest some language that might accommodate all of your concerns. And this follows Commissioner Bluestone's thinking. After the first sentence in B5, an addition of the following. In that event, the event being the director answering the request through an informal advisory opinion. In that event, the requester may still request that the commission issue a formal opinion.
That would satisfy my interest, yes.
Judy, it's your, we're on your motion. So are you acceptable to that change?
Well, if I could just add a little more discussion, I think in every situation, a requester time is not always the issue. So in some cases, I would imagine that a requester would ask for a formal opinion, need a formal opinion from the outset, and said, I've got 6 months to wait on an opinion. So why would we go through the motions of answering answering as an informal advisory opinion, and then go through all of the other machinations to make it a formal one, when that wasn't their pursuit in the beginning?
I'm not sure I understand that, but basically, can't you negotiate that at the outset when somebody comes in and it says, hey, I need a quick turnaround, or Jeremy or Walker, whomever, and they, like any other legal affair, can be negotiated, and Jeremy says, you know, you're probably better off doing this as a formal opinion. It's going to take longer, but this is why that might be better. I'm happy to do it. If you just want to do the informal, that's fine too. But I mean, it's everything in the legal world is negotiated. So I'm not sure that that's not the best flexibility.
Well, that's what I was suggesting initially, is that if there's any ambiguity, why don't we just ask them which they would want? That was my initial
I'm not
question.
sure that, my problem is I'm not sure that requires a rule. And every time you have a rule, you end up defining stuff you don't intend to. So I think I would agree with you on that. It's just, if it's not there, you can make that decision. It's not prohibited. And the motion before the commission right now is to excise proposed paragraph B, B5 on page 44.
Can I make a substitute motion?
Yeah, if it's okay with, well, I'm not going to get overburdened with parliamentarism. We're already in the weeds a little, so go ahead.
Well, I think to preserve what Judy's trying to honor, and I think it makes sense, is if we kept B5 in, but added at the end of that first sentence so that it would read, the director or the director's designee may answer the request through an informal advisory opinion unless the requester objects, period. And then add in the sentence that Jeremy read. Which, could you repeat that, Jeremy?
Sure. What I proposed was, after the period, in that event, the requester may still request that the commission issue a formal opinion.
Yeah. I think that covers it, Judy, does it not?
I think so, but can we have a little more discussion on that first sentence? Were you going to strike out, was there going to be a strikeout on the word formal?
It's in there now, Commissioner Villanueva. If you want to strike it, then you can move to do so. Again, I think you make a point that it's maybe surplus, but I think it also clarifies the distinction that we're talking about.
Right. Otherwise, the last part won't make sense.
That's correct. The way I still read that is that if a person submits a request, if they submit a request for an advisory opinion, that's what they're requesting, is an advisory opinion. I don't understand where, and does not specify whether it is a request for a formal advisory committee opinion, but they've already asked you for an advisory opinion.
Well, Chair and Commissioner Villanueva, this echoes Commissioner Bluestone's point that often we get requests for advisory opinions and that person might not have read 1.8.1.9b, and they might actually be looking for a quick turnaround. Something they need in a day or two, particularly if it's in the middle of a session. And I don't want to be in the position of holding them to, well, you've requested a formal advisory opinion because you didn't specify informal under 1.8.9. And so we're going to schedule this in 7 weeks for the next commission meeting. I think we do need to allow the flexibility to take unarticulated requests and be able to issue informal advisory opinions if it's clear that what the person needs is an answer, as opposed to a legal defense that would be consequent to a formal opinion.
Okay, just one last comment is just that as a service that we're providing, I still believe that it should be up to the requester to determine which service he or she gets. Not up to the commission based on the time and a supposition that they need it in a couple of days. Because clearly, if they submit an advisory opinion, we have a definition of advisory opinion. It exists right there in A.
So Chair and Commissioner Villanueva, I agree with that. I think Commissioner Bluestone's motion allows the requester to kind of make that call as to what they ultimately want.
Which is what I'm suggesting is that, okay. Do you not talk to them when you receive the request? Or do you just unilaterally determine, will you just unilaterally determine that you will respond as an informal advisory opinion?
Chair and Commissioner Villanueva, I believe we do. We say we got it. We got the request. I'm pretty certain we do that in each instance. Walker, has there been times when you've just kind of got the request and turned it around that day, and the first communication back was, here's some advice?
Not for a request that doesn't specify whether it's an informal or, I have turned around an opinion without further correspondence when the requester says I'm requesting an informal advisory opinion. But I cannot think of a time where I haven't had some further communication with the requester if they haven't specified what sort of opinion they're seeking. It's usually pretty clear from the request, though, what they're asking for. I know that we're sort of dangerously close to like sort of being a workshopping this, and I don't want at the risk of, I don't want to cloud the city further, but I do feel like I have a way to clarify this B5 in a way that I think will address the concerns are being raised. And I just want to read out what I think would be a good fix without talking about objections. And that is to just say that if a person submits a request for an advisory opinion and does not specify whether the request is for an informal advisory opinion, the director or the director's designee may, with the requester's permission, answer the request through an informal advisory opinion. And so that I think gives the flexibility to have a dialogue between the requester and the executive director. It does make it a part of the rules. It's not like we're deleting the whole rule, but we also don't have to have the requester be intimately familiar with 1.8.1.9 and know that they need to make an objection before in order to ensure that the formal opinion will be issued. And I don't know whether that proposed change is still going to give Jeremy the needed flexibility, and so I would defer to him on this. But that would be I just would say it's with the permission of the requester.
Jeremy?
Mr. Chairman,
Yes, Governor.
I move we table this motion and that the dialogue continue between Commissioner Villanueva and the staff to see if we can do this without spending a whole lot more time trying to edit this document. So my motion is to table this motion and have further dialogue.
Is there a second?
Second.
Second.
Second it.
Thanks. Anybody opposed? All right, thank you, Governor. The motion carries, and we will push that on to the next meeting. And hopefully all of you who are of the Scrivener class will collaborate and come up with the perfect sentence. I know it's out there and I know you can do it. Number 9.
So Chair, if you liked 1.8.1, you're going to love 1.8.3. So we're on to the rules of procedure. And there is another draft of those rules that includes language that was not issued for public comment. And it was language that was written to respond to concerns that Commissioner Villanueva raised about commission initiated complaints. And I believe that they are highlighted. I'm searching for the page number. Yes, okay, page 57. It highlights the note to the commissioners about these rules being different than what was issued for public comment. And the difference is at page 60 and 61 of the meeting materials. And so what you have before you is the rules of procedure as amended with what was issued for public comment and with this additional change on page 60 and 61. And I guess to give further background, I'd like Commissioner Villanueva to kind of voice her concern with the initial rules, but the proposed change here is an attempt to find a solution to where the commission can effectuate its power to initiate administrative complaints and still sit in an appellate capacity at the end of an administrative proceeding. And so with that, I'd like to turn these rules over to the commission.
Okay.
Mr. Chairman?
Yes, sir.
I think I'm on the right page where we have E4, where the director signs the complaint under oath and subject to penalty of perjury, that the information, the complaint, and any attachment provided with the complaint are true and accurate. I think that's well overshooting the responsibility of someone filing. That is way out in left field, unless it's in baseball. But a director should be able to sign a complaint without having to be subject to penalty of perjury with regard to true and accurate. Maybe their understanding is true and accurate, but it may not be. So I think that's an overreach, a big time overreach.
If I can underscore that, Governor, I agree, because the director by definition has to be a lawyer, so they're subject to the disciplinary rules anyway, which is kind of the same thing that attempts to do.
Chair and Commissioner Carruthers, it is worth pointing out, I think, that every complainant that files a complaint with the State Ethics Commission has to swear under penalty of perjury that the information is true and accurate. That's part of the State Ethics Commission Act.
Mr. Chairman, then I would respond, why are we investigating it then? If it's true and accurate, what's the investigation about?
Chair and Commissioner Carruthers, I suppose that the complainant could be wrong. They might.
Then it's not true and accurate. But they're under but they're under the same condition of subject to penalty of perjury. Is that correct?
If I could interrupt, this is added only in the instance where we as a commission, 5 of us, have agreed that we want to file a complaint against someone. And I agree with the governor that I don't think it's appropriate to put the burden on the director to be subject to penalty of perjury, that the complaint that we as 5 commissioners approve is something that he or she has to attest to, subject to penalty of perjury. The statute in and of itself provides that when any 5 commissioners vote to initiate a complaint, we initiate the complaint. So I don't think that E4 is necessary. But I do think Judy raises a very interesting question about the potential conflict between us as 5 commissioners initiating a complaint and then us as 7 commissioners sitting in judgment on the merits of the complaint. Personally, I believe that it's one thing to initiate a complaint because you think it's worth being investigated and looked into. And it's another thing to pass judgment on whether the burden of proof has been satisfied, that it's established a violation by a preponderance of the evidence. But I would like to get some legal advice from our staff about the constitutionality, if you will, of what our statute provides, where 5 of us can vote to initiate a complaint, and then we also sit in judgment on the complaint.
Well, that happens every day in courtrooms all over the state. Somebody denies a motion for summary judgment, somebody binds somebody over for trial, and in smaller districts, it's there. Just because you're making a determination of probable cause doesn't mean that you're finding a conviction.
But it's a different circumstance, I think, between being the prosecutor, if you will, and being the judge. Personally, I'm satisfied that the standards are such different that we could, as the statute provides, initiate a complaint if 5 of us want something looked into.
Yeah, I think we're seeing it the same way. I just don't see that there's a conflict there. I think you're right. I think it's set out. I like what this suggestion does. Yeah.
Yeah, and but the only thing is that I'm not sure that we should put the burden on all of those 5 commissioners to then have to affirm in writing that they can still make a fair and impartial decision.
That I agree with.
So I guess I would recommend striking E4 and striking the beginning or the ending clause of the next sentence so that it would just read, a commissioner's vote to initiate a complaint pursuant to this subsection E is not grounds for recusal pursuant to that section, period. And not put that additional burden on commissioners to have to affirm that they can still be fair and impartial.
Chairman. Chairman?
Yes, ma'am.
If I may, okay. My initial issue with the commission being given the ability to file a complaint was that how it relates to our rule on recusal. Because as Commissioner Bluestone stated, I don't believe we can be the complainant and the adjudicator. So the attempt to remove the commission or keep the commission from having to recuse, the entire commission from having to recuse, was the clause that Jeremy proposed. I had this discussion with him, and this was their proposal on how to fix that. The recusal rule says when a commissioner has a personal bias or prejudice concerning a party to the proceeding or has prejudiced a disputed evidentiary fact involved in a proceeding prior to a hearing. For the purpose of this paragraph, personal bias or prejudice means a predisposition toward a person based on a previous or ongoing relationship that renders the commission unable to exercise the commission's functions impartially. It, regardless of whether the director or the commission signs the complaint form, the complaint form statement says, by my signature below, I verify that the allegations contained in this complaint, along with the attachments and exhibits hereto, are true and correct to the best of my knowledge and belief, and that I believe the allegations herein violate New Mexico law. Regardless of whether the 5 commissioners or the commission as a whole signs the complaint form, or the director on our behalf, neither one of us can file the complaint and then be involved in the adjudication of the complaint. So there has to be a recusal somewhere. Or we have to address the recusal rule. Because by signing that statement, there is no way that you can convince anyone that you are unbiased just by that statement alone. And my concern would be is that not only should the commission, as we've spoken many times, not operate with any type of violation, we should not have any appearance of impropriety. And that to me is a very big appearance to overcome, is to say 5 members of the commission are filing a complaint and we're not recusing ourselves. Or as E would suggest, 5 commissioners want to file a complaint and go to the director, who will do it on our behalf, and he signs the statement, and then he's involved in the adjudication process, or the commission is. I see
Anyone
that
else?
as being, I see there's being conflicting.
Anyone else?
Conflicting rules.
Anybody?
I guess, Mr. Chairman, a commissioner determines that they want to allege a violation of state statute. They bring it to the commission. It takes 5 commissioners to say, I think there's enough validity here. We'll take care of this. We'll look into it. That, in my way, does not do anything to those 5 commissioners at all. Those 5 commissioners say, well, I think it's reasonable we look into this thing.
It's a
Now, maybe the
probable cause.
commissioner bringing the complaint may have to recuse themselves, but I think we're trying to get way overly restrictive in some of these rules. For
Well,
Pete's sake, let's let the system work a little bit without trying to codify everything that we do.
Well, and I think a determination, as you suggest, as I alluded to earlier, one of probable cause doesn't mean that you have convicted. It's just, yeah, there's enough here to go forward.
And I don't see that the 5 commissioners who agree to that have sold their souls and have to, affirm to anything with regard to their religion, their background, or anything else. Why do we determine that the commissioners aren't doing the job that they were supposed to do? I just think there's a lot of overreach in this statement here, as far as I'm concerned.
Anyone else? All right, so Jeremy, bring us back to how we got here.
Okay, well, I think as a result of this discussion, I heard what is a proposal by Commissioner Bluestone, which is to excise out everything in E4 except for the sentence, a commissioner's vote to initiate a complaint pursuant to this subsection E is not grounds for recusal pursuant to subsection A of 1.8.2.8 NMAC, period. And if I understand Commissioner Bluestone right, that's what he would propose changing in this rule.
Is that right, Stuart?
Yes, I'm fine with that, or not having any of the language. at all. Either one satisfies my interest.
Okay, Commissioner Blueston, is that a motion one way or the other?
Yeah, I think to address Commissioner Villanueva's concern, it's better to still leave in that one sentence as you've stated it. But as an aside, I mean, that's the motion, but I still would like to see a written analysis from our staff on the propriety of 5 commissioners initiating a complaint and then the 7 commissioners sitting in judgment on it.
Like, we'd be happy to do that, and we've done some of that work already. So that's something we could provide you.
All right, so could you articulate the motion, please?
The motion is to just have as paragraph 4, only the statement, a commissioner's vote to initiate a complaint pursuant to this subsection E is not grounds for recusal pursuant to subsection A of 1.8.2.8 NMAC.
Is there a second?
Second.
All right, any other discussion on that? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
Commissioner Chair votes yes. So that paragraph is amended. All right, keep going, Jeremy. That's something like a rule compared to what we've been doing here. So I will.
So Chair and Commissioners, that was the only change to the rules that were noticed for public comment. And I suppose with that amendment, the staff seeks a motion to adopt 1.8.3 as amended.
Is there a motion?
I thought we just did that.
No, that was just to excise that one portion of it. We're going to adopt the whole thing that we just, including the amendment we just made.
But Mr. Chairman, don't we have a piece of it still out for discussion between?
No, that's a different rule. That's the one we tabled. That's a different rule.
That was 1.8.1.
We're dealing with 2 different rules, and we tabled at your wise suggestion 1.8.1 till the next. We'll take that up later in the year, and then 1.8.3 is the one we're on now. It's a different rule.
Gotcha.
Okay, so is there a second to the motion to adopt 1.8.3 that we've just amended?
Second.
Okay, so Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. 1.8.3 as amended today is adopted. Thank you. All right.
Thank you, Chair.
Yes, and now I will seek a motion in a second to go into executive session pursuant to NMSA 1978 1015 1H3 and 1015 1H7. Is there such a motion?
So moved.
Second.
All right, anybody opposed to that? Hearing none, we are moving into executive session. Walker or Sonny, I'll give you time to do that. Let us know when we're ready to go. Shall we go ahead?
Yes, sir. There's a quorum. In fact, everybody's here,
All right. Except for Jeff,
except
but
for Jeff.
that's okay. We can get more done without him. So, All right, we are back in open session and Jeremy, you want to roll through these?
Okay. Yes, sir. So in administrative case 2021 09. The staff seeks an order dismissing the claims for lack of personal jurisdiction.
Is there a motion and a second?
Asking everybody to unmute. I see you.
So moved.
Thanks. Is there a second?
Second,
All right, Commissioner Baker. Thumbs up. Yeah, Commissioner Bluestone,
yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Villanueva,
Yes,
Commissioner Solomon, sorry.
Yep, yes.
Sorry, Ron, and chair votes yes. Okay, that order shall issue. Next matter.
Okay, and administrative matter number 2021-010, the commission staff seek a 90-day extension in this case.
Motion in a second.
So moved.
Second.
Mr. Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes,
chair votes yes. 90-day extension is granted. Next matter, 2021-011.
In this matter, the staff seeks a motion to refer the complaint to the Office of the Attorney General to delay notifying the respondents and to close the administrative proceeding.
There a motion to so act?
So moved.
Second, anybody?
Second.
Thanks. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes,
Commissioner Carruthers.
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes,
chair votes yes. Let the matter be referred as per the motion. Thank you. It's adopted. D 2021-014.
Okay, in this administrative matter, the staff seek a motion to dismiss the claims against the complainant against to dismiss the claims against the respondents for lack of jurisdiction and failure to satisfy the filing requirements under the rules of procedure and to close the administrative case.
Is there a motion, a second?
So moved.
Second.
second,
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
yes,
chair votes yes. The motion carries. Thank you. And finally, 2021-015.
Here, in this administrative matter, the staff seek a motion that the commission dismiss the claims both for lack of jurisdiction and pursuant to section 1016G 9C and D.
Thank you. Is there a motion, a second?
So moved.
Thank you. Is there a second?
Second.
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
yes.
Chair votes yes, the motion carries. All right, the next item on the agenda is for the next meeting, which would logically, or at least as far as we have been doing it, October 1st. Is that fine with everybody? That would be the next meeting in the the every 2 month last Friday that we've been considering. We're good with that?
Yeah, I
Yes,
just wanted to ask the staff, are you comfortable with these every other month meetings? Is that working out okay for you?
It still is, Commissioner Bluestone.
Everybody good? Okay. And so public comment, I will leave that to the computer wizards to figure that out.
SEC.
I assume you're referring to me, Chair, even though sometimes I doubt my own abilities.
As compared, you are a wizard.
All right, we do have some members of the public present. If you would like to make a public comment, please raise your hand. Again, you can do so on your computer by pressing the raise hand button. And if you're on the phone, by pressing *9 on your handset. All right, I don't see anyone raising their hand, Chair.
All right. And typically we do get those pretty quickly, so I'm comfortable that the time has been adequate. Which means item number 15 is before us. Anybody have a burning desire, or are we in adjournment per consensus?
Move adjournment.
Yep, we're there. Thanks very much, everybody. Meeting is adjourned. Everybody be
you.
safe and
Thank you.
well. See you in a
Thank
couple
you.
of months.
Y'all
Celia,
be safe.
you're not a rookie anymore, Celia.
Right.
Take care.
Bye-bye.
Bye, everyone.